Great, management report.
Thank you for the date article newsletter. Help serve their cause out there because it's a difficult job. Good that that's there. They can't hear. I'll try to speak up. I have some references to serving alcohol beverages and some of the license requirements. They reappear under the tab for the rental agreement for the clubhouse. So I won't discuss those. I do have an update on item 3, which is the D&O insurance claim update. I just received notice today, verbal notice, we will receive written notice this week, that CNA will not cover the association because for some unknown reason they are linking a 1984 claim settlement agreement to this case. So we don't know the detail. They would disclose that, but they will in a written notice. And I would recommend at that time, upon receiving that, the association appeal that through the attorney Juan Cardenas, because Juan has that experience with CNA and knows many of their principals in that firm. So I would think he might be a good candidate for the cause.
That means that the association and its directors are on their own as of this instant in time. There is no insurance coverage for.
That's what the insurance companies are.
Okay.
But they're not requesting punitive coverage.
No, I understand, but we've already incurred costs. I would think, because we've had to respond, have we not?
Yes.
And there will be additional.
$5,000 deductible.
Okay. Okay. But the bottom line is we don't have coverage as of according to the insurance.
All right. And the other bottom line is the association has incurred costs to defend itself and to defend the 5 directors. And so we've made that decision. Probably we have to resolve as a board to go on and do that. Certainly we're going to defend ourselves, but I think the board has to resolve that we're going to also defend the individual board members and association costs.
I think one of our documents already says that they will do that.
Do they? No, I think it says they have insurance.
I think it talks about insurance.
We need to check that. But no later than next board meeting, we need to deal with this, if it isn't already done.
Maybe we need to deal with it a little bit now. I mean, certainly I'm in favor of doing just that.
I have no problem doing something now that will come us together, because certainly the association needs to fund any expenses.
Absolutely. I'm totally in agreement with that. My issue is the firm. As you know, that firm has charged us a lot of money. In my opinion, excessively charged us money. RBD. I fully am supportive of the association paying for whatever legal fees, but not with RBD. I think the cost would be extravagant, excessive, and I would much prefer to see us go to, say, Mason. And I think the cost would be much more in line with reality if we would do that.
Do they handle this now?
Yes. I just cannot sit here and justify another open blank check to Rees Broome. Because before you know it, they'll be into us for $100,000.
I personally am insulted and I object to your accusation that we give anybody an open blank check to spend their money. I think there's no basis whatsoever for such an accusation.
Well, okay, then I want to talk to that, Wayne. I really do. I want to talk to that. This year, we have been ill-served by our professional support people, by the legal firm, by the auditing firm. Earlier this year, we approved, or last year, I don't remember what it was, we approved a certain amount for the auditing firm. They've exceeded that by a tremendous amount. I didn't approve that. Did you approve it? We gave them, we essentially said, here's what you can spend. They came back and billed us more than that. Same thing has happened with Rees Broome. They go off, we tell them to work a problem, they come back after the fact, 6 weeks later, and hit us with a $100,000 bill. Does anybody ask them up front, okay, Mr. Rees Broome, how much is this little piece going to cost us, and you can't spend any more than that? I allege that we do not do that. And as a result, I consider what they do is run open loop. And then after the fact, long after the fact, they come back and they say, here's what we expended, send us a check. I don't want to do that anymore.
If you build in a cap, like with any firm, they will build that into the contract too to cover themselves. So you're paying it either end, I would think.
The rates charged by Sagan, Mason, and Mason are lower. We've seen no churning on their part. They don't consult one lawyer with 2 or 3 paralegals, with 2 or 3 principals, as does Rees Broome. We've got evidence, bill after bill after bill, where they've charged us many, many, many hours for internal consultations. I don't want to participate in that anymore. This association cannot afford, we don't have unlimited funds. I want to see a responsible firm handling our legal fees, not one of these guys that's an ambulance chaser.
I wasn't defending.
Well, I also take objection to calling Rees Broome Diaz irresponsible and an ambulance chaser. I think there's no basis for those comments, John. We can discuss costs and whether we want to use one firm or another, but let's stop calling people names.
That's fine. That's fine.